And Misty, I'm just wondering, when you see that these were the questions that the jury had, they deliberated just a little under 4.5 hours yesterday. They had these 4 questions, including jury instructions. But let's first talk about this meeting, and why the importance of what Pecker had to say about that.
This really popped out to me. The fact that the jury was starting with this meeting in August of 2015. This is when Pecker, Michael Cohen, and Donald Trump meet. And from the prosecution's perspective, this is where they all agree to suppress these negative stories. And by the way, also promote negative stories about Trump's political opponents. They decide to do this at this meeting. And from the prosecution's perspective, they said in their closing, look at all of the evidence through the prism of this meeting. This is where they have an agreement. This is where they become accomplices. And every single other piece of evidence should be looked at through this view. And that's how you see this accomplice liability theory that the prosecution is presenting. On another note, I also think it has 2 other really relevant purposes. Number one, it's very logical to start here, right? This is the beginning for the jurors to start here.
Chronologically, this is the beginning.
Correct. Chronologically, this is the beginning. But also, let's talk about Pecker's testimony, also asking for Cohen's testimony about this very meeting. So that leads me to believe the jurors are looking to maybe compare the 2, see where it deviates or see where it's consistent.
It's interesting because right now the way that they're doing it in the courtroom is that there's a court employee on the witness stand that is reading back part of the testimony, almost like an actor, right, would in reading lines, and then the other a person is also reading different lines of this testimony. And so basically, let's kind of bore into a little bit about what it is that the jury wanted to hear and what it is that was said. So one piece of testimony they're hearing this morning is what Pecker said about the Trump Tower meeting. Here's some of what he said on the stand. Quote, there was a discussion about that I was going to be the eyes and ears of the campaign. There was a discussion that I would be notifying Michael Cohen of any women that were in the process of or going to be selling stories, and I would notify Cohen that they would be available and that they would either have to buy them or take them off the market or kill them in some manner. So, again, very specific issues.
Very specific issues. And keep in mind, let's look at what the charge is, right? We have falsification of business records for the purpose to cover up another crime.
34 times.
Correct. And here's the predicate crime. 17-152 New York election law. It is a misdemeanor to conspire to prevent or promote an election through unlawful means. So here, what we're seeing, the testimony that's being read back, this relates to that idea of the conspiracy. They're agreeing to suppress these stories. And this is where the prosecution, where there might have been some areas where Donald Trump is not so close to the transaction. Let's think about it. The invoices Michael Cohen sends. He testified he generated those himself. Donald Trump does not sign all the checks. So there's these areas where Donald Trump isn't necessarily very close to the transaction. But if you develop this conspiracy theory and they're all acting in concert, every single act in furtherance of that conspiracy can be impugned upon Donald Trump, which is what the prosecution is looking to do.
Interesting, because right now they're asking, this is what is being read back to them, part of the redirect of David Pecker by Steinglass, and it's specifically the transcript portion about catch and kill and about Pecker's understanding of his role in all of this, and that he wanted nothing to do with the Stormy Daniels deal. But the fact that the jury kind of got together as a group for the first time yesterday, right? I mean, they were able to sit and assume their responsibilities for about 4 hours and 20 minutes. Does that tell you anything, that this is what could be the first 4 questions of a whole slew of questions, if they're looking at this chronologically, that would be, oh, that's why they're asking about Pecker. He was the first witness. Is it possible that they're just breaking this down brick by brick to something that you kind of alluded to this week,
right,
that a lot of this is brick by brick to build the wall? Is this possibly just first phase? Let's ask the questions and then go forward chronologically down the case.
Yes, first of all, I drink coffee, not tea. So, you know,
We're
tea leaves.
same.
But I do think that that's also a possibility. So there's a lot of different reasons why the jurors could start here. One could be, as you said, Pecker's testimony was at the very beginning of the trial. Maybe they didn't remember it. There was a lot of, in the closing arguments by the prosecution, you got to look back to Pecker's testimony because it corroborates Michael Cohen. It could be because there's somebody in there who says, I don't believe a word Michael Cohen said. And there's other jurors who said, you know what? It was corroborated by Pecker. Let's go take a look at Pecker's testimony. So there's a whole slew of reasons why this could be happening. But I do think the meeting itself, that is the first step chronologically. And it really speaks to that idea of conspiracy. But we could absolutely hear more questions because keep in mind, we have documents, 34 different business records that serve as the very basis to this case. And this meeting and the testimony we're hearing about, this really relates to that predicate crime, that election law conspiracy, more so than the falsification of the records themselves.
And the readback is over. Judge Merchant is back to his mic, and he just says right now that completes the readback. Have we responded to your notes? That's what the judge is asking the jury. Okay, please let me know if you would like to have headphones or speakers, and that's about whether they want to have each headphones to plug into the laptop with all of the information that they have at the jury room, or do they want a speaker so that more than one person can hear it? Apparently, they want both things. They want speakers and they want headphones. The judge, of course, saying, we will provide that to you, and is now telling the jury members that they can step out. I will excuse you now to continue your deliberations. You can step out. Misty, all of these questions were answered, as was the jury's request to get the instructions, actually part of the instructions, read back to
Right. So this is actually a little inside baseball, because the reason the judge puts this on the record, says, have your questions been answered, is that could actually be an error on appeal, something that could overturn the case.
Explain that. What do you mean?
So if the jury were to ask questions, or to ask to hear testimony, or to ask to review a piece of evidence, and the judge, for whatever reason, declines to provide it to the jury, it's a potential appellate error. So after the jury asks these questions, the judge presents, we did the readbacks of the testimony, the judge reads the jury instructions again, he asks the jury, were your questions, did we respond to your questions? The jury says yes, and that's something that is an appellate issue, and that's the reason why you see the judge do that in the courtroom.
It's so interesting. And very quickly, Misty, when, one of those, the thing of what exactly is a way to understand what, reasonable doubt is or not, the analogy of rain,
Yes.
is really an interesting one, because it kind of helps you conceptualize something much more clearly.
Right. It's something that is used in jury instructions in New York and in other jurisdictions, that if you go to sleep and you wake up in the morning and you see the ground is wet and you see people in galoshes and raincoats with umbrellas, well, you can draw a conclusion that it rained last night, even though you didn't see the rain. So jurors are allowed to use common sense. You don't leave your common sense at the door in all of your life experiences. Jurors are allowed to draw conclusions based on the evidence that was presented. And that's all part of understanding what the legal standards are, because reasonable doubt, and it's been
really
criticized, it can be an abstract concept, and it can mean something different to everyone. It's not no doubt, that's always in the instructions, but it doesn't mean that you've alleviated every doubt under the sun, but it's a very, very high standard in the criminal law, and it has to be based on actual evidence, not speculation.
No doubt, more than just a 1980s band.